Today, Prime Minister Mark Carney announced that Don Farrell, a Veteran Energy CEO, would be heading up the Major Projects Office, which is designed to fast-track projects of national interest, things like ports and pipelines and LNG projects and whatever else they can come up with. And the argument here is that the Canadian regulatory environmental impact assessment has been too rigorous, too much regulation, too much red tape. We're going to streamline all of that, and we're going to get building again. Remember that during the election campaign? Build, build, build. So I thought I would take a little bit of a look at the environmental impact assessment and, the changes that Carney has brought in under the One Canadian Economy Act, Bill C5. And I have a lot of questions, and I will have to see how this gets resolved because, we don't have a lot of details right at the moment, but bear with me here, okay? So here's some comments from Carney. For too long, the construction of major infrastructure has been stalled by arduous, inefficient approval processes, leaving enormous investments on the table. So, depending on who you talk to, that's hundreds of billions of dollars or more. Carney also said the Major Projects Office will work with provinces and territories to achieve a one project, one review approach to environmental assessments. And the idea is that these approvals will come within 2 years. So here's a couple of points. First of all, there was a Canadian Energy Research Institute study back in 2018 that looked at these kinds of approval processes in Canada and compared them to the ones in the US for the energy industry. And what it discovered is that the basic approval process is pretty cumbersome on both sides of the border, and they were about the same. Canada didn't take any appreciably longer time, except in one area, and that was Indigenous consultations. It took about an extra 19 months because the Americans don't have that written into their constitution. We do. It's in Section 35. It has to be done. And, invariably the Indigenous nations challenge it in court. You remember the Trans Mountain expansion in 2019. The decision went against the project, and the government had to go back and spend 9 months doing consultation properly, which it hadn't done. So that was the main thing. So don't think that the Americans, at least historically, have been all that much better than we are up in Canada. It's about the same, aside from that one point. Here's another little point. Not very many Canadians have heard of the Office of Energy Dominance, which is in the Trump administration. And of course, President Donald Trump has the doctrine of energy dominance, and he created an energy dominance council. There's about a dozen people in it, and it has one purpose. If you have some kind of a coal, oil, or gas project, and it's caught up in red tape, you call up the Energy Dominance Council, and they will snap to it, and they will make sure that your red tape gets cut. And doesn't that sound a lot like the Major Projects Office? So this is what's going on here has roots elsewhere. And the idea is to get stuff built. The question is, and I did an interview with Professor David Wright at the University of Calgary, law professor, and he said you can build it fast and it works great, or you can build it fast and break stuff. And haste makes waste, as Mom used to say. Okay, so I want to talk about this a little bit because Carney's claim that the process has been arduous and inefficient and so on, it bears some pushback on this. But now there were a couple of last decade, there were a couple of revisions to the way that Canada goes about doing environmental impact assessments. So in 2012, Prime Minister Stephen Harper brought in a major revision. And then in 2019, Prime Minister Justin Trudeau brought in another revision. And the oil and gas industry absolutely hated that bill, and for a number of reasons. But I've talked to another law professor at the University of Calgary, Sean Fluker, who said, in reality, he said that the changes from 2012 to 2019 weren't that significant, and certainly were not the kind of doom and gloom that the industry is complaining. And this is one of the key points here. And this is something I've learned over the years. When you hear politicians start parroting industry narratives and industry slogans, you know, like this in the environmental impact assessment's inefficient, is taking too long, yada, 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 be suspicious, because what's happened is that the industry has lobbied the politicians, convinced them of their point of view. They've adopted that language. Nobody's done the homework to determine whether this in fact is true. Nobody's gone and done. They just simply agreed, and they've adopted the industry's requests. So I'm suspicious, and here's one of the reasons why. One of the things they say is, Carney made a point of this in his announcement today, is you have a provincial assessment and you have a federal assessment that's inefficient. It's not what happens. There have been any number of very large projects over the years, including into the Harper years and into the Trudeau years, that were done under a joint review panel, or they were done under a harmonized assessments, jointly developed and conducted by the province and federal government, or sometimes, in the case of a joint review panel, the two parties get together. Or one, sometimes if the federal government thinks that the provincial government standards meet its standards, it simply then allows the province to do it. So this idea that there's been two levels of government reviewing and taking their time and wasting time is not accurate. And furthermore, I wanted to give you some examples of projects that you'll recognize that come under a joint review panel. So federal and provincial cooperating together. Site C Dam, the BC government and federal governments, and that the BC Dam, Site C Dam just came on stream a couple of weeks ago. Muskrat Falls, another big dam in Newfoundland and Labrador, joint review panel. Grassy Mountain coal mine in Alberta and federal government, joint review panel, got approved. And the Site C Dam was approved in 8.5 months. So where's the beef, folks? And there's a number of now let's talk about legislative timelines under the current Impact Assessment Act, because this is not open-ended. The Act actually has timelines. Now, it's longer than 2 years, granted, but here's what we have. And there's about 5 phases here. So the first one, planning phase, up to 180 days. The next one is the impact statement phase, up to 3 years. That's prepared by the proponent. So to some extent, if you're proposing a pipeline, the pipeline company could get on its horse and do it a little more efficiently, perhaps. The impact assessment phase, conducted, that's the next one. And depending how it's done, it could be an agency-led assessment, the federal or provincial agencies, up to 300 days. It could be integrated, then it gets 300 days. But if a joint review panel gets up to 600 days. So, and then the final one is the decision-making phase, which is 30 days for the federal minister to make a decision. So how does this all pan out in real life? Because the real life does not line up with the timelines. And the Canada West Foundation undertook a review of projects under the Impact Assessment Act and found that on average, federal assessments take approximately 3.5 years. Now, the problem with that doesn't sound like an onerous amount of time. The problem is some of them didn't take very long at all. For instance, the Jack Pine mine expansion in the oil sands, 11.5 months. Frontier Oil Sands mine, which didn't get built, was a proposal from Teck, the big mining company, 8.5 months. The Deep Geologic Repository in Ontario, where they're going to put all the nuclear waste, 17 months. So the problem here is that some of these were delayed by protests and legal challenges and other problems, and they took a decade. Or they took more than a decade. That's the problem. Might have been an average of 3.5 years, but and invariably a lot of that delay was around energy projects like pipelines. Trans Mountain expansion was a good example of that. So It's not as cut and dried as the prime minister would have us believe. There aren't two federal review processes. It seems like in most cases, they're combined with the federal provincial government or delegated to the provincial government. And it's not, on average, it's quite reasonable. There's lots of examples of very fast approvals, and it's the really long ones that seem to drag out the average. And the difference between what has gone on in the past, like under Harper to 2012 and Trudeau to 2019, and then change, the changes were not radical, and they were in fact were designed in many ways to streamline the process. So when you can see where this is going. I mean, the prime minister talks about all sorts of things. We're going to have energy infrastructure, clean energy. We're going to have conventional energy. So when you're talking conventional energy, you're talking about oil sands expansion. You're talking about pipelines to the coast. You're talking about LNG plants. That's in conventional energy. That's about it. Then clean energy. He wants to do uh, power grid, a national power grid. So you're going to have interties and you're going to have to build transmission lines, which are incredibly politically volatile. Trust me, especially in the US, we've seen lots of NIMBYism. So there's a very real danger here that while we want to build and build quickly, that we're going to build and break stuff. And if you watch my interview today with the chief, the hereditary chief from the Wet'suwet'en nation in BC, they're digging in for a fight. And you can't get around this stuff. Their rights are enshrined in the Constitution, and they will take it to court and challenge it. And the history shows that they win most of those challenges. And then it has begun, yeah, the government has to go back and redo it again. And so we should view this whole approach to this with a great deal of skepticism, because I'm sure there are efficiencies that can be found here and there, and we can tighten it up and do it better and make it shorter. But we can't trample on the rights of Indigenous communities. They're protected by the Constitution. They're protected by the courts. And we also have to worry about environmental issues and climate issues. These are really, really complex issues. So we should not sacrifice doing it right for doing it fast, I guess is my point. And to date, the way the Prime Minister has handled this, the way his Energy Minister, Tim Hodgson, Minister of Natural Resources Canada, I'm not impressed. I think they're trying to rush this through and create a rubber stamp. I think the chief's criticism that this office is a rubber stamp for things like pipelines, I'm greatly concerned about that. So we're going to be reporting on this on a regular basis. I'll come back with some expert interviews. We'll kind of take apart some of these issues, and then we'll monitor it as these projects roll out. But there's some cause for concern.